जी।
कि हम जो इसको जवाब नहीं दे रहे थे, दुनिया के सामने लेकर नहीं आ रहे थे, तो अब तो इसकी हिम्मत इतनी बढ़ गई थी कि हिंदुस्तानी को अगवा भी कर लो। पहले तो था कि हमारी सीमा में प्रवेश हुए हैं, लेकिन अब वो तो नहीं हुए थे, तो इनके ऊपर आप आरोप लगा देते थे। कितना आसान है किसी को रॉ एजेंट बोलना, कितना आसान है किसी को आतंकवादी बोलना, और ये नहीं समझते हैं कि जब हम किसी को आतंकवादी कहते हैं तो उनके परिवार को और उनके देश पर क्या बीतती है। ये शब्द को सुनकर आतंकवाद कहना बहुत आसान
आप किसी को अगर आतंकवादी कहें तो उसका सबूत पेश करें, प्रूव करें उसे। द फाइनल मिनट टू मिस्टर Arasan Singh. I've overshot time, but I have to be fair. Arasan Singh, sir, please conclude this part of the broadcast. You have been wanting to make a point. Go ahead.
No, my limited point is that what is going to be essentially decided today, whether the International Court of Justice has jurisdiction over the case or not. That is the moot point. Because we went to the ICJ because we were denied consular access, and what Mr. Harish Salve has done is that he has painted the accentuating, circumstances and environment in which we were denied consular access, and Pakistan is exactly going to contest that the ICJ has no jurisdiction. I suppose we are on a very, very robust ground, and well, I can't stick my neck out on such a sensitive matter, but I can tell you one thing. I mean, I'll be very surprised. I'll be very, very surprised if we are not successful in our bid.
Absolutely. I think the arguments are very convincing and the grounds have been very convincing, and I concur with a lot of the opinions that have come forth. We're taking a very short break, turn around at 6 p.m. We continue with this story. I thank my panelists for joining me on this broadcast. Thank you. From the live wire into the prime pulse, the focus is on the hearing at the ICJ that is about to commence, and Pakistan will be putting forth its arguments. One wonders what arguments do they have, because all indications are that India will be able to get that stay on the execution. That is the first step. as for its multi-layered plea at the International Court of Justice, which Pakistan has also agreed, and it is going to come and defend its position. A quick check of the headlines as we bring you up to speed on the developments. The world watches as India exposes Pakistan's kangaroo justice proceedings in the Kulbhushan Jadhav case.
India believes that the farcical nature of the proceedings and unjust trial by a Pakistan military court.
Strike one. India's counsel Harish Salve explains why Pak Army Court's trial was completely farcical and prejudiced in nature, with the sole purpose of hanging Jadhav.
India submits that it has a strong prima facie case as to the jurisdiction of the court.
India preempts Pakistan's lame excuses and defense, tears into the logic that International Court of Justice has no jurisdiction. In 4 points, Pakistan's claims destroyed.
Disputes have arisen between India and Pakistan when India asserts, and Pakistan presumably would deny, violations of the Vienna Convention.
As
Bright sunlight is convincing. Anything which is in the dark is always suspicious.
After demolishing Pakistan's claims on Kulbhushan Jadhav at the World Court, Harish Salve speaks exclusively to Times Now, says anything in the dark is suspicious. Its lies completely exposed and claims destroyed. Pakistan's Attorney General will now attempt to justify his kangaroo court's actions. That comes up at 6:30 p.m. this evening. Times Now has accessed Pakistan's defense strategy. The rogue nation plans are here on Times Now. We keep you ahead in the battle for justice for Jadhav. The biggest reporting team and experts on the channel. Your channel at the top of the reportage with the fastest updates and the widest coverage. Now, this is the senior counsel Harish Salve just getting ready to leave the hotel and make his way back to court to listen to what his Pakistani counterparts would say in their defense as the hearing commences in a short while from now. Rahul Shivshankar, our editor-in-chief, joins us from the Mumbai Newspit. Rahul, whatever arguments will come forth will sound very hollow.
Yes, from what we are being told now, Anand, is that Pakistan is going to rely exceptionally only on the confessional video. So they're going to play that confessional video, if not play it, at least apprise the ICJ of the contents of that video. And we are being told that there are a few witness testimonies that will be produced by Pakistan to bolster its case. But beyond that, Pakistan will have a very tough time establishing the whereabouts and the activities of Kulbhushan Jadhav, because India has said, and very stridently so, that he was abducted by Pakistan from Iran, brought, and then an arrest was shown on the books, really, in Balochistan. Now, they will have to establish how he landed in Balochistan, if they were tracking him, on what basis can they prove that his locations could be traced and tracked to Balochistan? And also they have to prove that he was spying, because if they can't, there's a big problem there, because the problem is this, that they first tried him under the OSA, and they tried him under the OSA, and they said he was a spy, and therefore they also said very clearly that there was no way that he was an individual who was working as a businessman. And also, of course, there is the larger point, Anand,
yes,
that needs to be brought out very, very clearly in this entire deposition by Pakistan, that this individual has been given his due rights under the process of law. Now, how do they bring all that out? They'll have to tell us who his lawyers are. They'll have to establish how the lawyer, what material evidence he brought before to basically give Mr. Jadhav the right to defend himself in a full manner. They will have to also tell us whether Mr. Jadhav is alive, whether he was in the straight mental capacity, in fact, to even represent himself. Let's go across to Danish. Danish joins me from right outside the hotel where Mr. Salve is staying. Danish.
Yes, that's right, Rahul. Actually, I'm outside the Peace Palace, and we expect Mr. Harish Salve to arrive here at any moment. We've already seen some Pakistani delegation members going inside as well, because it's 2:30 here local time. There's a clock tower behind me, and in half an hour's time, Pakistan will begin its argument. And as we were saying, it's going to be a tough task, a hard task for Pakistan to establish two clear things. One, that Kulbhushan Jadhav was indeed involved in espionage, and second, that he was given a fair chance. Now, Harish Salve in his arguments has already countered those two key issues, saying that India has been requesting consular access right from the day India was made aware by Pakistan Foreign Secretary about the arrest of Kulbhushan Jadhav. And after that, it's been a total of 16 times.
Okay, I think we've lost Danish there. I just want to bring in Jonathan. Jonathan, if you can hear me, can you confirm whether Harish Salve has now left the hotel and if he said something to you on his way out?
Yes. Well, he left the hotel just literally 2 minutes ago. He just drove away while we were setting up for this live. Yeah, I mean, we've basically been pestering him with questions all lunchtime. We did an exclusive interview with him around half an hour ago, and I quizzed him quite extensively about how he felt his performance went down this morning, why he chose the words he did, describing Jadhav's conviction as farcical, and whether he thinks Pakistan have any kind of leg to stand on in their submissions this afternoon. He came out again, having obviously changed into his QC's attire, and very dapper he looks too. And he's literally on his way back to the Peace Palace as we speak. He'll be arriving there within the next couple of minutes in order to hear the rival submission from Pakistan.
Okay, stay on with me. Stay on with me. Let me just very quickly cut back to that interview we just did when Harish Salve got off the treadmill. The moment he came back to his hotel, he changed into his gym clothes and went straight to exercise, perhaps his body and mind together. But we caught him right after his workout, and Jonathan put a few pointed questions to him. Let's just play that entire sequence out, because it's telling. It seems that he's quite confident that India has made a strong case. Just listen in.
Harish, how are you? John Gilbert from Times Now. That was quite a workout. Looks like you deserved it. How do you feel it went this morning?
I think it's okay.
Yeah.
We all saw it, heard it.
Yes. But what was your instinct? Did you feel the judges were receptive to you?
Yes.
Yeah.
Yes, definitely.
Why did you describe Jadhav's conviction as farcical? That's very powerful language.
It's there in the transcript.
Yeah.
Without consular access, incommunicado.
Yes. And all the other factors you mentioned as well.
Exactly.
I mean, just remind us of those.
Absolutely. Anything which is in bright sunlight is convincing.
Yes.
Anything which is in the dark is always suspicious.
Do you? What convinces you that he's even still alive?
We hope.
Is it simply just a question of hoping?
Yes, and we haven't heard to the contrary.
Yeah. And do you think there's a danger, even if he is alive, that Pakistan might expedite his execution just to get this out of the way?
That's why we applied for urgent measures.
Yeah.
They've the agent in his opening mentioned they've, I think, executed 10 or 12 people last month.
Yes. Yeah.
So,
Well, do you think Pakistan has even a leg to stand on in terms of their defense?
I'll tell you 4:30.
Okay, good luck.
Well, it's interesting because when that question was asked, do you think Pakistan had legs to stand on? Harish Salve said, we'll have to wait and watch. And that's really where this entire case rests, on Pakistan's own deposition today, presentation today. Does it actually have material fact? Because if it did, it would really want to, in fact, present it to the global community, because the argument, Anand, that Pakistan wants to bring to the table is that India is fomenting trouble in Balochistan, that India is using agents linked to the RNAW, India's own agency, to try and destabilize an important province of Pakistan. That is precisely what Pakistan wants to prove. And that is the reason why Pakistan ordinarily should welcome using a global stage to expose India. But what we've got here, Danish, is in fact a Pakistan that is running away from the global table, from the global stage. They don't want the ICJ to be brokering this. They don't want the ICJ to be mediating this. They, in fact, want the entire focus away from this case. They want it to be tried in their internal military court. They want the appeals process to go to a military tribunal which will be headed by a two-star general. Do you think a tribunal is going to go against the verdict of a military court which is underwritten by the army chief? No, that cannot happen. I mean, it goes against logic. It would have to be someone extremely upright, someone very unmindful of the consequences to go against his own boss. And that, as we know, will not happen, because military chiefs in Pakistan are really prime ministers or presidents in waiting. They are dictators and have been dictators. They control every equation in Pakistan. So Pakistan, the very fact that it's resisting international scrutiny, convinces a large number of people, including perhaps Harish Salve, that their case is very weak. Now we can see Harish Salve driving past where Danish is, and I want to bring in Danish. Danish, go ahead. Danish, go ahead.
Well, yes, Rahul, as we can see, that's Mr. Harish Salve's car that's just entering. Of course, he will be very much glued to what Pakistan has to say. As he told my colleague John as well, that he wants to see what kind of argument Pakistan makes. But there, if we can just have a glimpse at his car going right inside there. And then, of course, in just 20 minutes, less than 20 minutes is when Pakistan's deposition will start. The argument being made by Pakistan will begin. We can see the car going inside as well. They belong to different delegates, of course. Harish Salve, as we have seen, has already gone through it. And very glued, as he said, that he's looking forward to what kind of arguments, what kind of points Pakistan will raise on the issues that he has very clearly and with no ambiguity presented before the International Court of Justice. And as you were speaking, Rahul, earlier about how Pakistan will try to make a case about this being an internal issue, those were some of the points on which Harish Salve also based his own argument, saying that this is something which the International Court of Justice has to take cognizance of. And as we know that the International Court of Justice, in fact, took this matter at a record speed. It's very rare for the ICJ to come up and order a stay or any kind of hearing that takes place. And yes, that's Mr. Harish Salve. I think he's just entering the court premises. Inside, the time is 2:45. It's just about 15 minutes before Pakistan starts making its argument. Rahul?
Absolutely. And who's going to be leading the Pakistani argument? We are also being told, and we have that, we have a graphic, in fact, prepared for it. There is going to be some underhand tactic that is being employed or has been employed by Pakistan. They brought a Ministry of Foreign Affairs official, a bureaucrat, along with them, who looks after UAE and the Gulf countries. And they brought that individual and they sat him down during India's deposition only because that individual is known to a particular judge, a judge that is part of the panel, the 11-member judge panel, that bench rather, that is hearing this entire matter. So there's some underhand plot and an attempt at trying to influence the outcome of this case by using their influence upon one of the judges who they presume is sympathetic to their cause. So Pakistan already up to dirty tricks to try and influence the bench. Now, I don't know if this is successful or it will backfire. I would presume it would backfire, Danish, because this is really skullduggerous activity. But Pakistan is one of those countries that is known to buck every international norm, including, of course, in this particular case, the Vienna Convention. Danish.
Yes, Rahul, absolutely right. But what matters here, what matters now for this particular hearing are the arguments, are the points, are the law citations, and how forcefully you make those points. We've seen Harish Salve. Now all eyes, of course, will be on Pakistan, even though, as you said, they have been trying their best in whatever means they could. We heard echoes that any ruling or any order from the ICJ will not be binding on them.
Well, there
and that
can
it's a
only be
matter
a
of Pakistan.
forceful intervention, Danish, if you really have hard facts at your disposal. The point is, Pakistan will peddle lies, and they have known to peddle lies, because in the entire run-up to this important day, Pakistan's entire case has been a fabrication based on a confessional video which looks as if it was a badly managed and orchestrated production job, where a man under duress, perhaps even with a gun pointing to his head out of camera, is made to go and incriminate himself. And it was so awful, the production quality, that you could see the blips. And you know, Shafqat Saeed, the lieutenant who is with us, Lieutenant Colonel Shafqat Saeed from, yes, the Lieutenant Colonel who is with us, is laughing away because he knows it's such a con job and it can't be taken seriously. So he is laughing, as he would be. But I can tell you, the ICJ is not amused, sir. And when they see this absolute slapjack of a job that you have put together, a slapdash job that you've put together, they will realize it's a massive con. And I can't understand, if Pakistan is so convinced of its case, why doesn't it just come out and say, yes, we accept the jurisdiction of the ICJ. Let's bring it on. We don't care. Let's have this. Let's put it all out. But why is Pakistan running away, Lieutenant Colonel?
What did you do in 1999 in August, once Pakistan went to International Court of Justice on downing of Atlantic Airline? You opted out of the ICJ jurisdiction, saying that the matter pertains to the security and defense, and therefore it is not in purview of the International Court of Justice. Exactly like that, Pakistan has just to make one line out.
No, but you won the day. You won the day, and that's why. No, Lieutenant Colonel, because you won that day.
And it does not
because you won that time. Because you won that time, you have a stronger moral argument to make today. So, if you really want to have a stronger moral argument to make on this particular case, you would say, okay, we'll disprove India once again. Bring it on. Let's go back. You already lost once. We will teach you another lesson. Come, let's debate it. Let's argue it. Let's put the facts out there.
This is the time you have to learn a lesson yourself. I want you to know the exact points that we are going to plead on, and I would like you to know them. First of all, the consular access point. The consular access, Article 36, has two paragraphs. Number one paragraph spells out that what are the modalities that the consular access to a person is to be arranged. And the para number 2 says that the consular access is regulated by the receiving country's law and regulation. And it is only possible if the receiving country allows it, its law and regulation allows it. And international humanitarian law, it says, it specifies that there are 3 types of peoples in the receiving country that are held prisoner. One is the combatant, then is civilian, and third is spy. And the additional protocol to the international humanitarian law, it further describes the spy. And in this case, the Kulbhushan Singh Yadav does not fall under the category of combatant or what?
I understand that point, and that's the one that we've demolished in court, because let me tell you, sir, that amendment that you have made has not been registered with the United Nations, and that's the problem. It's a municipal law. It's a municipal. It's a change at the municipal level as part of a bilateral agreement which hasn't been registered, and that's where the real problem arises for Pakistan. You haven't registered it, and therefore the international covenant takes precedence. In any case, sir.
There is a point. When did you do it?
No, it does not require.
When did you do it, Lieutenant Colonel Shafqat Saeed? When did you do it? When did you do it, Lieutenant Colonel Shafqat Saeed? When did you do it?
March 2017.
March 2017. That is the reason why. Kulbhushan Yadav case does not fall under its ambit. That's the reason why Kulbhushan Yadav case does not fall under its ambit.
The lawyer wants to come in.
Yes, Aman Sinha.
Let me bring in Aman Sinha, the lawyer. We'll get a legal response to this. Aman Sinha, go ahead.
Yes.
Go ahead on this point about actually registering an amendment.
Well, whatever the gentleman from Pakistan is saying, he's absolutely.
Yeah, go ahead. Go ahead, sir. Go ahead.
It's absolutely self-contradictory and self-defeatist statements, Rahul. And in fact, the whole case is that there was no trial at all. It was a sham trial. There is no evidence which they can bring forward before the ICJ. There is no charge sheet that they have filed in this matter. Therefore, there is no basis to what the gentleman from Pakistan is saying. Now, he believes that ICJ is the apex, the highest court globally, is going to believe whatever divine truth that comes out of mouth of Pakistani people. That is not going to be the case. There is no basis for what the gentleman from Pakistan is saying. And let me say, Rahul, that it seems that they are extremely shaken and stirred by whatever happened.
It's pretty obvious. It's pretty obvious. Stay with me, Mr. Aman Sinha. We're also joined by Dr. Abhishek Manu Singhvi, who joins us today in the capacity of a renowned lawyer. Dr. Singhvi, we made a very strong intervention today at The Hague. And at the bottom of our intervention is one point, that the bilateral arrangement between India and Pakistan does not stand. Could you elaborate on that point? You've heard Harish Salve. You're also somebody who is familiar with law as it stands extensively. So if you could elaborate on that, there is so much confusion over whether the ICJ has jurisdiction or not on this particular matter.
The entire country stands behind Jadhav and the government's attempts to get him back or get him off. I think the whole world sees Pakistan as exposed as dealing in anti-human rights activities without even minimalist due process. There is absolutely no doubt that ICJ jurisdiction stands, because the basis of the ICJ's, basis of Pakistan denying jurisdiction is to retrospectively try and insert a national security exception clause to its consent to jurisdiction. Please remember that for all these years and decades, Pakistan has conceded jurisdiction. They have now tried to claw back with a clause giving a national security exception. Even if its legality is to be adjudicated for the future, it cannot and should not be allowed to operate in respect of actions qua Jadhav, which had taken place much before. That's the point I would like to make.
That's very
Jadhav's
interesting.
actions or actions against Jadhav by Pakistan commenced months ago.
Months ago.
Months ago. This clawback attempt is much more recent.
Much more. April this
much
year.
More recent.
April this
Now,
year, and
in
it
that
seemed to have been done
Pakistan
to preempt India's move to go to the ICJ. Yes, absolutely. Self-serving.
Yes. Well, going to the... can I just... It's very opportunistic and self-serving, because preempting somebody's move to go to ICJ is not anyway relevant test. The test is that when you took under actions which could be subjected to international scrutiny, were you subjected to an ICJ clause? And in this case, you clearly were. More than that, there's another aspect. The final decision is far away. We are not, 99.9%, we're not going to get a final decision from ICJ right now or in the very, very immediate future. Today's skirmish is entirely on the interim arrangement, which is really based on a very, very strong Indian position, as it should be, of balance of convenience. Forget the final outcome and verdict, which will depend on legal niceties, jurisdiction, etc. The issue today is, should the execution be proceeded with even while the ICJ is seized of the matter? Balance of convenience suggests that if the execution goes on, this is irretrievable, irreparable, irreversible, and ICJ would have nothing to decide whether jurisdiction or not. Therefore, I would be astonished if the ICJ were to respond otherwise than with at least what they call a provisional interim measure of status quo, namely preserve the subject matter of the dispute, which is a human life, that of Mr. Jadhav, till such time as you can come to grips with the final matter, because these are legal skirmishes to take time.
Absolutely, they will, and that's really the endeavor here. In those 90 minutes, Harish Salve made a compelling case so that ICJ, which is a UN court, would move towards maintaining the status quo. Now, I wanted to ask you, Dr. Abhishek Manu Singhvi, from a strictly legal point of view, What do you believe will be Pakistan's response? What we are being told is that they are relying exclusively on a confessional statement. Will that be enough?
There are two levels of the merits here, and obviously these are not fully known at the moment, but two levels. One level is the preliminary level of the merits, which is that you have no jurisdiction, Mr. ICJ.
Yeah.
And we have clawed back, we have made an exception, we have withdrawn, etc., etc. The point I've already answered or dealt with. Well, the second is going to be that on the merits, national security is a subject or an area which is not reviewable. It must be governed by the local national laws of Pakistan, and that Mr. Jadhav is a spy, and national security therefore stops you from scrutinizing it. Now let me tell you that first of all, even under domestic law, and I'm now of course speaking a bit hypothetically because you don't know Pakistan's exact stance, but even under domestic law, let me tell you, an absolutist stand by anybody in India, or for that matter in Pakistan, which is very, very similar or identical laws to India, suggesting that even a military court's verdict is absolutely unreviewable under domestic law is a false notion. It is a wrong notion. Every country governed by a constitutional document will have more than reasonable judicial review and scrutiny powers, and so will that be of a military court.
Yes.
So Pakistan's attempt to suggest that it is purely shrouded beyond judicial review of the International Court of Justice because it's a military court in Pakistan and not subject to review would be wrong, even under its own national laws, which are very similar to India. And I know that in India, even a military court, which acts like a kangaroo court, does not give due process, does not give access, does not give, for example, in this case, charge sheets, charges, proper hearing, counsel, etc., etc., would be clearly hit by the right to life under domestic law, which Pakistan has, at least in theory, as much as India has.
There you go. That's the important point, Lieutenant Colonel Shafkat. You presided over a kangaroo court, and now there is going to be a consequence to be paid for it. You've heard it. It's quite clear. Not even a document given to the Indian side or to Mr. Kulbhushan Jadhav, which can determine on what basis you've in fact gone ahead and decided to hang the man. I mean, that's the least you could have expected.
Kulbhushan Singh Yadav was working directly under, he was in direct contact with your national security advisor, and he was not working through the chains of the security agency.
That doesn't matter, sir, but even a terrorist like Kasab, those are the live pictures coming in. I can't understand the logic that Pakistan seems to be falling back on. Because he was a alleged spy, he has no human rights. That's bizarre. That is absolutely bizarre. There come in the judges one by one. There are 11 of them, headed by a president, in fact. Abraham, there he comes in. I think Abraham, that's the man who is just adjusting his spectacles. He's going to take a quick seat. They're all come in order. They all know where they're sitting, and therefore they walked out in that order, so there's no confusion and no one's running around trying to figure out where they're sitting. So they'll all sit in order. There's Mr. Abraham, and he's going to be presiding over this entire trial, as he has since the morning. Recess of about 3 hours. Let's cut live.
L'audience est ouverte. L'audience est ouverte. The court meets this afternoon to hear the oral observations of Pakistan on the request for the indication of provisional measures submitted by the Republic of India. I now call upon Dr. Mohammad Faisal, representative of the Islamic Republic of Pakistan. You have the floor. You have the floor.
Your Excellency, the President of the International Court of Justice, honorable judges of the court, Excellencies, ladies and gentlemen. I'm honored to appear before this court as Pakistan's agent and to make the following remarks. The delegation from Pakistan includes Ambassador Moazzam Ahmad Khan, myself, myself, Khabar Qureshi, our counsel, Barrister Asad Rahim, Mr. Joseph Dyke, Assistant Legal Counsel, and Mr. Faraz Zedi, Counsellor. Mr. President, I will provide a brief overview of the response of Pakistan to this application, and then invite our counsel, Mr. to develop the submissions, why this application is unnecessary and misconceived. Mr. President, I am compelled to observe that whilst we share so much with the applicant state, we are on very different sides today. For our part, we wish that were not so. Moreover, for our part, we wish to make it absolutely clear that we remain committed to the path of peaceful resolution of all disputes, whatever the provocation. Having faced the evil of terrorism on a daily basis, with deadly attacks only last Friday, killing 26 people, and another killing 11 people on this Saturday, in the area where Commander Yadav was operating before his capture, we know only too well how the poison of hatred is used to achieve political ends by others. That is why, despite being ambushed into appearing before the court on a few days' notice, we are here. We are here because we will not be cowed by terrorism, nor will we allow any attempt to malign or misrepresent our position or legal processes to go unchecked. We will use all legitimate means to protect our people, our territory, and our reputation from attack. Robustly and resoundingly, inshallah, always. Unfortunately, India has seen it fit to use the International Court of Justice as a stage for political theatre. We regret that this has been done. We will not respond in kind. Our counsel, Mr. Qureshi, will explain why it was wrong for India to invoke the exceptional provision mayor's jurisdiction of this court, the judicial organ of the United Nations. He will touch upon the reasons why the court should not otherwise exercise any jurisdiction or entertain any aspect of India's engagement of its jurisdiction. Indeed, it is somewhat ironic, but perhaps consistent, that India complains that it is not being given access to Commander Yadav, who has confessed to having been sent by India to wage terror on the innocent civilians and infrastructure of Pakistan, and in the same breath has urged this court to make an order without giving Pakistan any opportunity to be heard. We are disappointed that India did not take the opportunity to be transparent soon after 25th March 2016, when the Foreign Secretary of Pakistan protested in the strongest terms to the Indian High Commissioner regarding Commander Yadav's criminal acts. India has been provided with the copy of the passport that was in the possession of Commander Yadav when he was apprehended. You can see the copy of the passport on the screen there. Mr. President, as the court can see, the passport bears a Muslim name, which plainly is not the name of Commander Yadav. India has been unable, or perhaps more accurately unwilling, to provide an explanation for this passport, which is the most obvious indication of covert and illegal activity. India could simply have denied that the passport was genuine. We submit that India's silence is telling. Indeed, India could and should have responded to a letter of request dated 23rd January 2017, seeking India's assistance to investigate the criminal activity and links with people in India, which Commander Yadav has revealed. Instead, India appears to have been in hyperdrive mode to brief its press that Commander Yadav, a 47-year-old man, took early retirement and was kidnapped in Iran, from where he was brought to Pakistan to give a false confession, presumably. We fully understand that this court is not concerned at this stage with an evaluation of the merits. We are not sure what merit there is in a state which sends a spy and terrorist seeking entitlement to untrammeled access to its tool for terror. However, we consider that it is important for this court to hear the extracts of the confession which were made public on 25th March 2016. On the same day, the P5 and the EU were also informed of Pakistan's grave concerns in this regard. Indeed, later that day, extracts of a video of the confession of Commander Yadav were made public. I intended to share the extract of the video, just around 6 minutes of the video. I understand that the court has viewed the video, but would prefer it not to be shown here. I should make it clear that the video is publicly and readily available for anyone who wishes to see it. The viewers can decide for themselves whether Commander Yadav is confessing voluntarily and comprehensively. India will no doubt say that the candid and contrite confession was exhausted by foul means. That would, of course, be very wrong in every respect. Mr. President, India has sought to persuade this court that we intend to execute Commander Yadav within days. Despite India having selectively quoted from the contents of Annex 8 to its application, the court can see for itself that this is totally false, simply by reference to the clemency process available as a right to Commander Yadav. A period of 150 days is provided for in this regard, which even if it started on 10th April 2017, which is the date of conviction at first instance, could extend to well beyond August 2017. There is also, of course, the potential for the writ petition of the High Court to be invoked, as we believe India must be well aware. Pursuant to Articles 184(3) and Articles 199 of the Constitution of Pakistan, individuals have successfully obtained relief from the courts. India and Pakistan have a common source for the vast bulk of our legal processes and procedures. More importantly, if the court will forgive my language, we simply have no reason to stop the canary from singing. Others might wish that. We do not. Just to make the point absolutely clear, an expedited hearing which would dispel any suggestion of the need for provisional measures is an approach that Pakistan would invite the court to adopt. On this basis, Pakistan would be content for the court to list the application of India for hearing within 6 weeks. We have no desire to waste the court's valuable time and resources in trying to score political points. Indeed, Mr. President, it is noteworthy that the Indian media widely reported your letter to the parties dated 9th May 2017 as a, quote, victory, unquote, by means of it being a, quote, stay order, unquote, which plainly it was not. This surely is a valuable insight into what really lies behind this maneuvering. I conclude, sir, where I started. Whilst we were bounced into appearing before the court, it is always an honor to do so. The Islamic Republic of Pakistan cherishes the freedom which was gained 70 years ago. It wishes to live in peace with its neighbors and hopes they will soon appreciate the virtue of such an approach. I thank you, Mr. President. I would request the court to invite Pakistan's counsel, Barrister Khawar Qureshi, to make his submissions, please. Thank you very much.
Je remercie l'agent de la République islamique du Pakistan et je donne à présent la parole à Monsieur Qureshi, Conseil pour le Pakistan.
Mr. President, members of the court, it's an honor for me to appear before you on behalf of the Islamic Republic of Pakistan. On a previous occasion when I appeared before this court, it was in the context of a situation of real urgency. Exceptionality was plainly involved. That was in the context of the Genocide Convention being invoked by Bosnia and Herzegovina to seek and eventually obtain provisional measures from this court to try to stem the flow of blood that was all too clear. In this case, I will invite this court to dismiss the application that has been brought before this court on three bases. Firstly, there is no urgency. Second, the relief that is sought is manifestly unavailable. And third, so far as jurisdiction is concerned, the jurisdiction under the Vienna Convention of 1963 is not as untrammeled as my learned friend has suggested. It is limited. And indeed, it is further limited and qualified or supplemented by the 2008 agreement, which the applicant state has been at pains to disavow. An agreement that has been in place for 10 years, and it's now being suggested it's not relevant. It's also being suggested that because it did not comply with the requirements of Article 102.2, it cannot be placed before this court. It's rather unfortunate that having brought the respondent state before this court, the applicant state seeks to rely upon what can best be described as a technicality. However, I begin by referencing the conduct of the applicant. The applicant has sought to invoke and obtain the most exceptional relief from this court. And it has done so, as paragraph 23 of its request makes clear, by urging this court not to permit an oral hearing. If an applicant seeks to invoke such an extreme jurisdiction to deny the other side a hearing, it is incumbent upon such an applicant to ensure that it provides a court with full and frank disclosure, that it ensures that the documentation and information placed before the court is accurate, and that it ensures that all material facts are placed before the court. As I will demonstrate, there are, unfortunately, flaws in the approach of the applicant in every respect, so far as these three fundamental elements are concerned. Firstly, paragraph 20 stressed that without provisional measures, Commander Jadhav would be executed before the court could consider the merits. Indeed, paragraph 21 stressed that there was such immense urgency that this might happen any day. And therefore, it is not surprising that when one seeks to invoke the jurisdiction of the highest judicial organ of the United Nations, indeed, the highest judicial organ that all members of civilized nations turn to, that the President issued the letter on the 10th of May, as he did, in the terms that he did. It was said in the application, furthermore, that the trial was rushed through and that Commander Jadhav could be executed summarily. The papers before the court, within the application itself, demonstrate at Annex 6 the detailed public statement made by the advisor to the Prime Minister on the 14th of April, His Excellency Sattar Aziz, that none of that is, with respect, true. There were 4 stages of the trial, 21st of September to the 12th of February 2017. The clemency process was identified clearly, the timeline, 90 days plus 60 days. What's also said to this court in the application, paragraph 9,
is that the Pakistani authorities had made it clear that Commander Jadhav was not eligible for consular access, nor would he be granted consular access. The court was referred to Annex 7. Regrettably, Annex 7 says no such thing. What the applicant has sought to do is to introduce as Annex 11 an article from a newspaper, which, whatever else it may be, is not a newspaper of the record in Pakistan. But what is important to note is that there was plainly a material misrepresentation in the application that was placed before the court as to the position of the authorities of the Islamic Republic of Pakistan. Because, in fact, Annex 9 to the very same application provided a draft transcript of a 3-page press briefing provided by the spokesperson to the Foreign Office. And the court will see at page 3 that in answer to a direct question from a journalist, the Foreign Office official spokesman made it very clear that pursuant to the bilateral agreement between India and Pakistan of 2008, which India is anxious to avoid any reference to, the question of access to Commander Jadhav would be decided on the merits. The court has been given an indication, moreover, that there was some request for evidence made by the Pakistani authorities, but all that the court was given was the cover letter in the annexures. Unfortunately, the court was not provided with the substantive material which was given to India on the 23rd of January 2017, but it has now. In the judge's folder at Annex 1, the court will see that the material comprised a cover letter which identified 13 names that Commander Jadhav had provided to the Pakistani authorities. The cover letter sought the assistance of the Indian authorities to the phone records of Commander Jadhav. It sought the assistance of the Indian authorities to bank account details. These are all perfectly reasonable, legitimate requests. The Indian authorities were provided with a copy of the first information request, the details of the allegation, Annex 1. Annex 2 was a copy of the passport. Now, interestingly, at no stage has India made any comment about the possession of a passport by an individual whose nationality as an Indian national has been assumed, we say de bene esse, but has not actually been established by the Indian authorities. The passport plainly requires explanation. There is the confession, which is in the bundle that was given to the Indian authorities, together with, significantly, the United Nations Security Council Resolution 1373, one of the most important Security Council resolutions ever promulgated in the aftermath of the horrors of the attack on September the 11th. India, no doubt, would have been fully familiar with the principles identified in that resolution, but incumbent upon all member states of the United Nations is the obligation to assist, not only in preventing terrorism, but the provision of evidence. What happened? Deafening silence, no response. What's said in the application at page 24, paragraph 50, is that the confession of Commander Jadhav was obtained after India had sought access. Somewhat ironic, because as you have seen, and as the written submissions that are before the court will make clear, the chronology is as follows. Commander Jadhav was arrested in the southern province of Pakistan, Balochistan, which is mineral rich and unfortunately has seen violence all too often. He crossed in from Iran, bearing that false passport. The position, so far as the video is concerned, is that that video was aired. That was a confession video aired on the 25th of March, 2016. So it's plainly incorrect if it's being suggested that that video was obtained after consular access was sought, because the chronology simply doesn't bear it out. What's said, in addition, is that Pakistan, at the application paragraph 28, made it a condition of consular access that the mutual legal assistance request was complied with. And pausing there, I respectfully submit to this court that the obligation to prevent and to enable the punishment of terrorism is one of the highest obligations that all member states of the United Nations are subject to. Indeed, I would go much further and say it's an obligation erga omnes. It wasn't a condition on consular access, it was a fundamental requirement that India was to comply with, and it's yet to give an explanation to this court as to why it has not. And in fact, it's simply inaccurate, if not, with respect, misleading, to suggest that the government of Pakistan and its officials had attached conditionality. What they had said, and again, this is in the annexes before the court, Annex 3, the letter of the 21st of March 2017, before judgment was handed down on the 10th of April 2017, is that the consular access request would be considered in light of the response to the mutual legal assistance request so as to enable early dispensation of justice, so that the evidence could be provided to enable the legal process to take its course in Pakistan. Insofar as it's been suggested that the process that Commander Jadhav is subjected to is some form of kangaroo court, it's rather bizarre that a court exists in a state which is seeking to do justice and is asking for evidence in that regard, and is sharing evidence in that regard. So the position that's advanced before this court is, with respect, a sham. But what does this all get to? We saw in the request at paragraph 20 that the president was urged to act on the request for provisional measures because Commander Jadhav might lose his life any day. India generated a sense of urgency, not Pakistan. India invoked the jurisdiction of this court improperly, and as a result, has now, interestingly, shifted its position as to what urgency is. We began with any day, but my friend, when he addressed the court with reference to the Avena case, suggested that it was appropriate for this court to grant provisional measures where in the Avena and Mexico, the Avena Mexico case, the death sentence prospect was some 6 months away. Firstly, that's not correct. And second, it's not acceptable to invoke the jurisdiction of this court on the basis of imminence, any day, about to be committed, and then come to the court and say, it may be 6 months, that's enough for you. Because when one looks at the cases themselves, the 3 death sentences cases, they all relate to the use of capital punishment in the United States of America. In the Paraguay case, there was a period of 11 days before the death sentence would be imposed. In La Grande, it was the next day. And in Avena, the earliest that any one of those 54 Mexicans might be exposed to the death sentence was 4 weeks. Not 6 months, 4 weeks. And when one looks at the drafting history of Article 41, which this court in the La Grande provisional measures case helpfully provided an insight to, at paragraph 105, Article 41 relates to certain situations in which irreparable harm is about to be committed. About to be committed. There is plainly in that language a sense of immediacy, imminence, urgency. And 6 months plainly in nobody's book is imminent or urgent or immediate. The application conveniently glossed over the existence and availability of clemency, which was articulated in the advisor to the Prime Minister's public statement on the 14th of April, which was before the court, but was not drawn to the attention of the court. In the oral phase this morning, my friend indicated that action was likely to be taken before final decision is likely to be given. an elastication at best of the position that was placed before the court in writing. That simply will not do. This court has on its docket some of the most important issues engaging the states. This court exists to ensure that states engage in peaceful resolution of disputes. This court does not exist for time wasting and political grandstanding. The second point is that the relief that is being sought is palpably unavailable. In the oral submissions, what my friend said is that in the least position, at the very least, what is required is annulment. At the highest, forthwith release. The court will see this from paragraph 60 of the application. There is no realistic, plausible prospect of obtaining such relief from this court. It is not